Great. All right. So hello and welcome to another episode of the ICC Academy COVID-19 Briefing, an interactive video series where we explore the economic and health implications of this coronavirus pandemic and what must be done to ensure successful recovery for businesses big and small. I'm your host, Thomas Paris, and in this episode, we will discuss how arbitrators should approach requests from interim measures within the arbitral process, as well as special considerations to be taken in the COVID-19 environment. Joining us today is Eduardo Silva Romero, partner at Dechert LLP, Sophie Nappert, independent arbitrator in London, and our moderator is Živa Filipič, managing counsel at the ICC International Court of Arbitration. So as a reminder, during the session, we will start by running through a few pre-prepared topics, followed by an audience Q&A session at the end, though we will try and bring in a few questions into the dialogue as we go through. So we invite everyone to send their questions in the chat, and we'll go through them together as soon as we can. So let's kick things off. Živa, over to you.
Hello, everybody. Good morning, good afternoon, or good evening, wherever you are. We are joined today by two really leading arbitration practitioners, and we will discuss interim measures, a very, very important topic that even gained in prominence in the latest circumstances. So, starting with just a brief introduction of our speakers, although they really do not need one. But I just wanted to highlight a few facts about, first, Sophie Nappert. Sophie is, of course, a dual qualified lawyer in Quebec and in England. She is an independent arbitrator and has arbitrated in about 150 cases, very roughly. She is also an award-winning lecturer and speaker. She was the first person to win the GAR Award for the best speech. She's also very dedicated to promoting diversity in arbitration. She does a lot of capacity building in emerging markets and fights for gender equality. She's also really interested in the impact of technology, namely blockchain and artificial intelligence on the arbitration field. And she, of course, is lecturing around the world in her native country and everywhere else about arbitration. Eduardo is co-chair of Dechert's International Arbitration Practice. He was Deputy Secretary General at the ICC, and he, since then, is leading the practice at Dechert and acting as counsel, but also as arbitrator in about 100 arbitrations already. He is also professor of international investment and commercial arbitration at the leading universities in Paris and in his native Colombia. And he is a member of the ICC Court and the chair of the Latin American and Iberic chapter. Now, without further ado, I would leave it to Eduardo to introduce us into the topic.
Thank you, Živa, for the invitation, and hello, everyone. The interim measures issue is always very interesting because very diverse. And I just wanted to introduce the topic by pointing to some strategic considerations behind interim measures, and more precisely, what are the aims that parties may have when requesting interim measures. And to summarize, I think there are two types of approaches to interim measures. One can be characterized as a big picture type of approach, and a second one is more case specific. And let me develop these 2 points very rapidly. what are those interim measures that are used as a big picture strategic weapons, if I may say? These are those requests for interim measures that are aimed at forcing a settlement with the other side. It might be seen as a harassment, but if it is useful to get a settlement, it is a strategic weapon. And there is another a strategic way in which interim measures are often used, which is to put the case before the tribunal quite early. Through the interim measures, counsel and the party behind the counsel may have the opportunity to present the main, strongest points of their case before the tribunal, which obviously is an aim which may be related to the first one I mentioned, which is forcing a settlement. Now, coming to the second approach to interim measures, which I mentioned was or is case specific, what I see most often in practice is that the purposes of interim measures are mainly three. First, they are used to obtain or preserve evidence. These measures are more often requested from judges. We'll come back to that later. Then a second very, very often used way of interim measures is to prevent bank guarantees from being called. If I were asked what is the most common interim measure in commercial arbitration, I would say is probably stopping bonds or bank guarantees from being called. And lastly, perhaps more in the investment arbitration setting, we see interim measures aimed at staying proceedings. For instance, the host state of the investment has commenced administrative or criminal proceedings that can affect the investment, and the investor requests interim measures aimed at stopping or suspending somehow those proceedings, which is a very, very difficult venture, as we can guess. So I think this is what I can say, Živa, to kick off, and I'll turn over to you.
Thank you, Eduardo. So to also settle this in the current circumstances, of course, we're living an unprecedented health crisis, a pandemic which has reached over 7.5 million confirmed cases and over 400,000 deaths. This has had an immense impact on the economy. First of all, with the complete interruption of manufacturing and supply chains around the world, starting with China, but then spreading basically into every corner of the world, and even physical closure of businesses, of national courts, and to a much lesser extent, arbitration institutions. And I think this is important when we are talking about interim measures, because there is always this dichotomy between choosing to go to the court or choosing to go to the arbitral tribunal, so which we will say something more later on. Now, institutions have been very subtle in adapting to the situation. The ICC has the ICC's operations have not been interrupted at all. It has been operating throughout the crisis almost seamlessly, completely electronically. At the beginning of the crisis, we have issued communication to the parties to start filing requests for arbitrations electronically, and then and start offering guidance to the parties. And we have been able to process everything electronically throughout, including the court sessions. Luckily, we are a global institution which have teams and court members around the world. So we have been already operating, at least partially, remotely for the last quite a few years. So now just everybody is on the same footing. Now, we have then issued the guidance note on possible measures to mitigate the effects of the COVID pandemic. And those are addressed to the parties and to the tribunals, offering valuable guidance on the case management techniques that can be adapted to the current situation, on considerations on holding virtual hearings and so on. But not only that, also about how the measures that the Secretariat and the court have put in place to promote efficiency and avoid disruption, including electronic notifications of requests. The team in charge gets in touch with the claimant party to see if electronic notification is feasible. Then parties are encouraged to agree to electronic notification of final awards. When that's not possible, we notify them physically through the Paris office, which has been accessible at least partially, and we have been able to organize ourselves. So, and of course, requests for emergency arbitration. One would think that during these times of economic crisis, where really cash flow problems become more prominent, we would have seen a complete explosion of requests for interim measures and emergency arbitrators. I think there has been a certain increase, but not so dramatic yet. Although I do think it is coming. I think that companies and public entities have been, in the first place, really focusing on ensuring the health and safety of their staff, and have now started to, explore options for claims, and in which case then also protection in terms of interim measures becomes more prominent. And we have seen in the last week, we have received in the weekend, 3 requests for emergency arbitration. So, so that is really just to set the scene of our discussion. And although this will be probably really old news for many of you, we still thought it would be useful to also set the legal framework out very briefly. And I hand it over to Sophie to do just that. Sophie, and as we discussed, we will interrupt you, of course, all the time.
Yes, I hope so. Thank you very much. It's a great pleasure to be here. Fantastic to see people joining from everywhere, including Montreal, my home city, which is a special hello to you. Yes, I'm just going to, I'm sure I'm not going to teach everyone anything, but just to go over quickly the general framework. I mean, the first thing about interim measures, and it sounds an obvious proposition, but they are, there is an element of urgency, and so a tribunal must consider them as a matter of priority. They can be made, as you just were showing in the previous slide, Živa, they can be made at any time prior to the request for arbitration, right up until the final award, either in the course of a hearing, or they can be made in writing with supporting evidence or elements showing the criteria that I'm going to go over in a minute. So the important thing is obviously they have to be considered as a matter of priority. The first question for the tribunal is, do we have jurisdiction? Do we have jurisdiction to consider this? Do we have the power to consider them under the arbitration agreement or the applicable law of the place of arbitration? There is, in most developed jurisdictions, no impediment to that, but however, you have to be quite careful to look at whether, for example, your arbitration agreement has not reserved these to the courts, for example. So that's the first point. The other point that's quite important is to give both sides an opportunity to put their case forward. An exception to that of sorts, but it's not entirely an exception, is where there is an ex parte request for interim measures. I'm going to say a few words on that specific beast a little bit later on, where essentially you ask for submissions after having made your ruling ex parte. There is also a question mark on whether ex parte measures have as much force when granted by an arbitral tribunal as they do by a court, and perhaps we can have a bit of the point of view of Eduardo from the counsel side on this particular point a little bit later. What are the criteria that the tribunal should apply when considering a request for interim measures? Well, the first criterion is, and here I just want to go back to the very helpful introduction made by Eduardo. There is a balancing act by the tribunal to considering these requests. The parties, as Eduardo has explained, may be trying to force a settlement. There is an agenda, perhaps, behind this request, apart from the fact that it may or may not be well-founded. There is perhaps an agenda. It is very tempting for a tribunal to try to second-guess that agenda. You have to try to, unless there are intimations of bad faith or abusing of the process, you have to be a little bit careful about that as a tribunal. You have to really look at the criteria from an objective point of view. And those criteria are as follows. Is there a good arguable case on the merit, on the part of the claimant? And this is not a particularly high threshold, but the danger is, again, prejudging the case or forming a view as to the merits of it. It is quite dangerous to be seen to do that, or to do that even for yourself. But you do have to look at, does the case stand up on, giving the claimant the benefit of the doubt. So, which, in most serious cases, that threshold is fairly easily met. And the second criterion is, but if we grant this measure, is there a risk of harm that is not adequately reparable by an award in damages? So if it has to do with the preservation of evidence, for example, if the evidence or the dissipation of assets, is there, if you don't grant the measure, then the evidence is gone, and that you cannot essentially remedy that otherwise. Now, I don't know what you think, Eduardo, but I think that aspect of things is particularly impacted by COVID, I would have thought, because that particular criterion, I think, has a different gloss on it, that now that we are faced with a situation where you don't perhaps have access to physical assets as easily as we would have had before. I don't know. Do you agree with me? Or am I overplaying that?
I do. I do agree. And actually, that requirement that the party cannot be somehow compensated economically at the end somehow, it is quite complex in my mind, because I would say in 90%, if not more, of the cases, you can always compensate something through money at the end. So to what extent that requirement makes interim measures more complicated to obtain is a question that I have in mind.
Absolutely. No, I think generally my experience has been that tribunals are slow to accede to these requests for the reason that you mentioned, and also because it is, as I said, a balancing exercise, and you do not want to unfairly prejudice the party at the receiving end of the party that will have to to provide the measure in question. And for that reason, another criterion is, and that's often applied by tribunals, is the party that makes the request is often asked to put up a security to provide for any damages or any adverse consequences that the party that is ordered to provide the measure may suffer as a result. So there is a cross undertaking, either in the form of a bond or money put in escrow. So again, it's very much to do with making sure that both sides are treated fairly, and at the same time trying to protect something which the parties deem needs protection. So there's a proportionality exercise. Yes, sorry.
If I may jump in already with a question I see here, I think it goes very nicely to this question by Claudia Salomon. To what extent should the parties delay in seeking interim measures factor into an assessment of urgency? I think that has exactly the current circumstances in the back of it.
I mean, from my perspective, delay is a loaded word because it does depend what the circumstances are, and if by delay there is an element we think of strategy or trying to force the hand of the other party, that is certainly a concern or a factor that will be looked at. But my understanding of the criteria that are generally applied, and in English law, for example, I do not believe that there is a requirement, on my understanding of it, there is no requirement that the party seeking it must act with due dispatch. It really is a matter of circumstances and at what point that party gained the knowledge that there was a problem with dissipation of assets, for example. Obviously, they can't sit on it for too long, because at one point you wonder about, if you've been able to live with it for so long, and why do you need it now? But on the other hand, I don't think there is a requirement of, immediacy in terms of turning around and asking for it. From a party's perspective, Eduardo, I don't know if you would agree with me, but obviously the earlier the better.
Absolutely. To come to Claudia's question, I would say that on my experience, if a request is delayed, that might mean that it is not urgent, and that requirement is probably not met in the circumstances. But something else that came to mind while Sophie was explaining the requirements, and when she mentioned the risk of prejudgment, is perhaps the this is the great advantage of relying on emergency arbitrators, because they will assess prima facie the merits of the case, but they will not be adjudicating the dispute at the end. So that prejudgment issue goes away thanks to reliance on this new animal, if I may say, the emergency arbitrator.
And in fact, we did see a few arbitrators saying, emergency arbitrators saying just that in any event the tribunal will decide, unless of course the whole thing stops with the emergency arbitrator order and there is no arbitration, or the arbitration is ultimately withdrawn. But let's get to that in a few minutes, maybe. Back to you, Sophie.
Can I just add? Sorry, Živa, can I just add, I wanted to add a couple of things to my criteria, which are more, not really criteria, but again, on the checklist to be recalled, is obviously arbitrators, unlike courts, cannot grant interim measures against third parties. So you have to confine whatever measure you do grant to the parties before you, to do or refrain from doing something. And there is not, in English law, again, speaking from the perspective that I know, there is no power on arbitrators to impose penalties if, for example, for every day that the measure is not put in place. But I understand that things may be different in other jurisdictions. I don't know, Eduardo, did you want to comment on that?
No comments so far.
Okay. One thing that we did discuss before was the fact that and we've seen it in emergency arbitrator cases, where it's true that the arbitrator can only order the party something, but they can make the other side or the arbitrator can ensure that that order comes to the appropriate third parties. For example, inform the bank, inform the insurance company, and by sheer authority of the fact that that is a quasi-judicial entity, sometimes that has the effect. And I think that this is something that you wanted to discuss, Sophie, a bit later on. But it's true that sometimes the ex parte, the measures directed to a party actually have also effect on third parties.
They definitely, I mean, that's the point, is to have effect on a third party, but it has to be rooted through the parties before you, obviously. And so they, as you say, they have your measure will say, you know, to take every possible step to apprise the bank of X about this order and to put it in place, that sort of thing.
And in a way, the added benefit of having this, resorting to the arbitrator or the emergency arbitrator for interim measures as opposed to the court is that you're doing this, you're being seen by the tribunal that decides on the substance of the case, and in a way it's self-monitoring. Although it is only, it's not, it doesn't have binding nature. The party can still call the guarantee, for example, but it does help that that party will be reluctant probably to breach the interim measure order, knowing that it's the tribunal that will ultimately, it will come into very bad books with the tribunal probably.
Yes, I think that's absolutely right.
Well, what about domestic standards? The standards, if we go back to the standards of urgency, irreparable harm, likelihood of success on the merits, proportionality, you name it. Usually, the law of the seat of arbitration also has criteria. Are those relevant in your view, or not so much?
They are relevant. They definitely are relevant because you want something that will be able to not go against any particular requirements of the law of the seat. And if they are mandatory, then you have to take them into account as well.
Yeah, something interesting, perhaps in Latin America, is that the powers of the arbitrators in a domestic setting are those of the judges. And in the code of civil procedure in those countries, you have a list of the interim measures that can be requested and granted. So at times, those codes do not contain orders such as preventing someone from doing something. And you may have a problem of enforcement if the order by an international tribunal doesn't coincide with those listed in the code, which we have seen in some cases. But this is only a pathology, and we shouldn't pay a lot of attention to it anyway.
Yeah, since we are in Latin America, I think that there is also a requirement if you have arbitration with public entities, that if a tribunal orders, I think it's Peru that I'm referring to specifically, that if the tribunal orders interim measures, it has to order also security for cost. So that is coming to Sophie's point of if they're mandatory, they need to be complied with.
Absolutely, and there is another problem when state entities are involved, is that many times in the law, for instance, concerning construction dealings, you have a provision governing contract with the state or state entities, stating that the public servants are obliged to call the bonds or the bank guarantees in some circumstances. So the situation that the arbitrator or the emergency arbitrator may have is a request from one of the parties, the private contractor, asking an order against the state entity not to call the bonds. And then you have the position from the state entity saying, we public servants, we have no choice but calling the bonds, otherwise we may have problems as public servants in our country because we are not fulfilling our duty. And this is a very difficult question, I find, for someone dealing with a request for interim measures.
Indeed. Sophie, you already mentioned the fact that the tribunal has to invite the comments from the parties and give directions and obviously set the timetable for the dealing of the emergency on the interim measures applications. When we get to the end, there is of course the question of the decision, the form of the decision. Should it be an order or an award? And we discussed briefly before that there are quite a few considerations there on, of course, first the parties' agreement or the rules by extension, but quite a few other considerations as well there.
Absolutely, and it's a very important. Obviously, it carries very important consequences. A procedural order is I would say that's not written anywhere, but generally tribunals tend to prefer to proceed by way of procedural orders. They can be varied. They are very easy to issue without, in the ICC context, without needing to go through scrutiny. They can be, they're more nimble and more flexible. And whereas the award obviously is enshrined for all time. And certainly in a situation such as interim measures where you have to take a view on the prima facie validity of the case, you probably don't want to have an award, if you can avoid it, just to not run the risk of having been couching views that may be later considered to be in favor of a party or not in favor of a party. So what I'm trying to say in a very long-winded way is that prefer orders if you can, unless there are particular circumstances where the parties need something that they can then go off and enforce somewhere. It's preferable to have an order.
Yeah, indeed, we have seen usually in ICC cases, we have seen parties requesting, the applicant requesting an award when they were concerned about enforceability. I must say that in those cases, we do treat the scrutiny with the urgency that is deserved. And I just remember in my team, when I was still in a team, we had one request for an interim award on the interim measures, and scrutiny was done basically overnight. So just a message for the parties to perhaps not be too dissuaded by the fact that an award needs to go through scrutiny. Scrutiny can be done as fast as necessary if you have concerns about enforceability.
Actually, Živa, I think we had a case together when this happened in the middle of August or something, and I needed to have an interim award scrutinized in like 24 hours. Do you remember that? I think that's a couple of years ago. And I had you on the phone from, I don't know what lovely vacation place you were at, and it did happen 24 hours. Fantastic.
It's true that it's a difficult question. Often, perhaps the solution is to ask the parties what they want. And it happens that they say an order is fine, or someone, as Živa mentioned, says, we want an award on interim measures. But then obviously the issue is one of enforceability for the party who gets the order.
Yeah, and in case people are more interested in going into more detail on this question, in the ICC report on emergency arbitrators, there is an annex where there was a research conducted through the national committees on enforceability of interim orders, interim measures in general, and by emergency arbitrator. And it contains a few useful insights on the approaches or likely approaches, because there is not so much. I remember one judgment from Egypt, but apart from that, there is not a lot of judgments, both to show the self-enforceability, the self-executability of these decisions in the vast majority of the cases. But there is still some interest in at least crystal ball gazing in there on scientific basis. So I think we can move on, and we will, in any event, we will come back to all of that, because although we want to say a few words specifically on emergency arbitrator, the considerations are very, very overlapping between what happens when a tribunal in the main arbitration is asked to order interim measures or an emergency arbitrator. The difference being that the emergency arbitrator is only available to parties if they need urgent relief or conservatory relief before a tribunal is constituted. And now the Of course, there needs to be an ICC arbitration clause that needs to have been concluded after these rules have come into effect 1st of January 2012. Why am I saying this? Is because sometimes it is really not clear from the application whether this is complied with or whether the other requirements, which are quite simple, because there is no time to go into a complete complex analysis, which is that the parties to the emergency arbitrator proceedings need to be signatory or successors of the signatories of the arbitration agreement. And the parties are really well advised to spend a few minutes and a few paragraphs maybe explaining how those requirements are met, especially if they are under severe time constraints, as is usually the case, to get the matter going. The president of the ICC court will assess those and will allow the matter to proceed if those requirements are met. Then, of course, in terms of procedure, the emergency arbitrator has to issue an order within 15 days. That time limit can be extended by the president of the court, but is rarely extended. I think the average time of the 130 emergency arbitrators that we had so far was 16 days. So sometimes it's extended by parties' agreement. But from experience, one perhaps practical tip for emergency arbitrators is to also invite cost submissions by the parties, because an order has to decide on the cost of the emergency arbitrator proceedings, and those sometimes we see that the whole thing is a bit delayed, or there is a bit of a panic at the end when those submissions are invited ex post facto. And then another thing that some emergency arbitrators are faced with requests from the parties to extend the time limit for the filing of the request for arbitration. Indeed, some parties want to first see the order from the emergency arbitrator to even decide whether they want to go ahead with the main arbitration or not. And there, most of the some emergency arbitrators have granted that, and some have not. And I think that those that have granted it have been of the opinion that there is really no prejudice to allow that. But I think that there is another view as well, and I think that Eduardo wanted to say a few words about this, right, Eduardo?
Absolutely. I recall the discussions that occurred in 2011 before the emergency arbitrator institution was incorporated into the ICC rules. There were clearly two different views. One saying that this institution should be incorporated because other institutions had already done it, and it was an important means for efficiency in ICC arbitration. And there was another view saying that this institution should be examined more carefully before introducing it into the ICC rules. So the liberal and the conservative parties, if you will. And then at the end, it was incorporated with some safeguards. One of the concerns was that people could abuse of emergency arbitrators to harass the other party. And one of the safeguards was precisely to make sure that the applicant was serious, to require from that applicant the filing of the request for arbitration within the 10 days. And for that safeguard, the committee drafting the ICC rules in 2011 was inspired by many national legislations on arbitration, which require the filing of a request for arbitration or demand of arbitration within some time limit.
Well, in terms of what the emergency arbitrator will have to do, they will have to first set the timetable for this procedure. And we see two approaches from the arbitrators. One from the arbitrators. One is to simply set a time limit, set a timetable, and send it to the parties. And the other one is to first invite the parties' views. Some arbitrators have even held a telephone conference to first discuss this and then set the timetable. Do you have any preferences, Eduardo or Sophie?
Sorry, my mic was off. I didn't want to. I have a plane behind me. I always like to have, if time allows, I always like to have a conversation with the parties personally. I find it it's easier to get clarification of issues in a verbal manner, and it may. I think, I mean, to divert a little bit. I think this is probably one of those areas where virtual Zoom hearings are going to endure if we're not all completely fed up with them after the pandemic has blown over, just because of the immediacy of it and the fact that it can be done much more cheaply, and it's still better than it tends to be better than just a phone call. At least you're able to see each other. So that's my preference.
I agree. Interaction with counsel to understand well the issues is very important, and I believe in the future we're going to have more virtual hearings on interim measures. In our minds, before this crisis, when we discussed about hearings for interim measures, we were always thinking of in-person hearings. Now, I guess the paradigm will be different, and we will more easily have video conferences to interact with counsel and get right the different issues to make the right decision.
On the procedure, maybe just another thing that we have seen some arbitrators actually to immediately when they were seized to order cease and desist order ex parte while they get comments, while the request is even notified, the application is notified to the other side, and that has been usually, well, of course, an arbitrator is really advised to consider whether that is going to be well accepted in the place of arbitration and possible places of enforcement. But if that is the answer is yes, it is sometimes, especially when a bond is about to be called, it is something worth considering, and just so that people out there know that it has already been done on the basis that the parties have a right to then be heard, and this can always be, and it's always just do not do anything, do not change the status quo until we have the chance to decide this, and until I issue my order in the end of the proceedings. Very briefly on the fact that the emergency arbitrator needs to assess the admissibility, the requirements in the rules, plus the fact that this needs to be so urgent that it cannot await the constitution of the tribunal. So it's a bit of a analysis of how long it will take to constitute a tribunal of 3 members or of 1 member and so on. And then they need to also assess their jurisdiction. So things that can impact jurisdiction, among the most interesting is when you have a tiered clause, tiered arbitration clause, and there is a previous step to arbitration. And quite often we see then objections to the emergency arbitrator also lacks jurisdiction because the previous step has been yet complied with. There is, I think, something about this in the report, but I think in general, I wanted to put it to you whether you agree with what seems to be the prevailing view that those preliminary steps apply to the main arbitration, because the logic being that the parties need to first attempt to agree to settle the dispute before the dispute is finally settled in arbitration, whereas the nature of the emergency arbitrator is completely different. It is not there to settle the dispute. It is just there to order, to give relief that is urgently needed to the parties so that the arbitration can then be even held. So I don't know if we have any different views on that.
No, not from me. I think that's an accurate description and an accurate assessment. No, I'm sorry. I can't disagree on this one.
Same answer.
Yeah. And one thing that we have seen also sometimes is the tribunals actually declining their jurisdiction or admissibility on the basis that the measures are not interim in nature. For example, in construction context where the contractor wants to be reinstated into the site and continue the works and execute the project. I remember one emergency arbitrator held that would actually be already decided. There is no way back. There is no way to undo that decision then for the main tribunal. Now we have already touched upon the balancing act the arbitrators have to perform in deciding on interim measures. Now, we specific also focus on the current circumstances. What exactly you think are the key takeaways? I'm mindful a bit of the fact we have 15 more minutes, and I would really love to save some time for questions at the end. We have discussed when we were preparing this a few quite specific considerations in the current circumstances about what the tribunal should better keep in mind when deciding on the interim measures. And I don't know which one of you wants to go first.
Eduardo, why don't you start?
By all means, with pleasure. I think in the end, interim measures are a very pragmatic thing, and counsel and arbitrators should be very pragmatic about it. How does this pragmatism reflect upon the specific elements of each case is probably the question, and on experience, the balancing of the different interests of the parties is the best way to decide. We all know the different requirements that Sophie mentioned, but at the end of the day, the question is, if I order the interim measures, what would be the consequence on each of the parties? And if I don't, what would be the consequence as well on each of the parties? And then looking at all the consequences, one can make a pragmatic decision. One of the developments that I've seen, especially in ICC arbitration, is that arbitrators are more often looking at keeping the status quo in many of the decisions, rather than applying a strict criteria such as the fumus boni juris or periculum in mora that we all know from civil procedure. And last point is that this pragmatism that I mentioned needs to be controlled. It cannot lead to illegal or unlawful or unfair decisions. And let me give you one example. Many times the contract containing the arbitration agreement foresees the different bonds and guarantees. And those bonds and guarantees and those provisions were carefully negotiated by sophisticated corporations. So by ordering one of the parties not to call a guarantee, the arbitrators need to be aware of the fact that they might be rewriting a contract. So we should be pragmatic, but at the same time, there's always a risk of rewriting the parties' deal, and that, to the extent possible, should be avoided.
I just want to add very quickly, because I do want us to address questions as well, just to add to what Eduardo said. In the COVID-19 situation, one of the heightened, I mean, it's always a consideration, but this heightened consideration is obviously the fact that businesses may not have the cash flow or the resources that they would normally have. There may be physical impediments, as I was saying earlier, to getting to assets or to actually attach assets. And these are things that obviously the tribunal must keep in mind and perhaps be more ready to compensate with damages than otherwise would be the case, rather than leave a party without any recourse. I'm just going to stop here.
Mm-hmm. Maybe we can come back. We can come back to any aspects, but maybe we can just go to the to some of the questions now. One has Eduardo's name all over it. It's about investment arbitration, and it asks how the parties go around an eventual cool-off period in order to request emergency arbitration, whether it's through MFN clause, or if the urgency exists, the cool-off period seems to be a formal impediment for legitimate need for an emergency arbitrator. Is there anything to add to what we said?
Well, if the question is whether you can request interim measures during the cooling-off period foreseen in treaty, the answer is probably no. Because either national legislation or the applicable rules will require to file the request for arbitration within a relatively short deadline, and cooling off periods last, we know, either 3 months or 6 months. So I don't see how we can send the trigger letter, the notice of dispute, and at the same time request interim measures. That's something that should happen later, which in the end corresponds to the philosophy of those treaties, because the cooling off period is there precisely for states and investors to try to solve the dispute amicably, and requesting interim measures is an act of war.
Sophie is nodding, so
it's a hand grenade. That's what it is.
Eliteo is asking whether how often we see interim measures accompanied by astringent penalties for non-compliance. Sophie already said, I think, that she hasn't seen it much. We have seen it in a few emergency arbitrations, referring to, I think, the fact that this is an available remedy at the place of arbitration. Eduardo, do you have anything to add? Have you seen it?
Regarding fines, this is something you can see in France from time to time. Arbitrators imposing what is called astreinte. Then in some Latin American jurisdictions, but I would say that you see it more in a domestic type of setting. Is exceptional in my experience to see it in international arbitrations for the reason that Sophie explained before.
I mean, certainly in English law you don't have that power, and you have often, I find, from a very practical perspective, a very effective weapon. If there is no compliance, you can hit that party with a costs order at the later stage. So it's not as immediate, obviously, but it's something that makes parties think twice.
Something that comes to mind now, and I forgot to mention before, is I'm seeing more security for cost applications these days, which is somehow a paradox, because given the situation and following what Sophie mentioned, people without cash flow, so how some parties will buy the bank guarantee or place money into an escrow account in the circumstances, but at the same time the other side is concerned by the situation and wants to make sure that at the end of the day the final decision will have some positive economic effect and won't be there against a bankrupt entity. So there, I think, is where the balancing of the different interests plays out well, and depending on each case, the result should be hopefully fair.
Do you think that the very exacerbated cash flow problems are changing somehow the standard for granting or not granting security for costs? We know that in England, I think the standard is very, very high. It's really willing dissipation of assets or or some kind of really like insolvency or similar. But we see parties now asking for security for costs, not so much because of an insolvent situation, but because of the lack of cash flow that they are afraid of. Is that something that is new, or it's just more exacerbated now?
I mean, the ability of someone to fund or not fund an award in damages is always there, has always been there. It's quite important to probe that quite seriously, because security for cost is a classic strategic tactical request, and so the standard is exacting in English law, but it's not insuperable. Obviously, this is impacted by current circumstances, but as Eduardo said, it's likely to impact both parties in a similar way. And so I think for the tribunal, you have to take a very pragmatic view and perhaps revise numbers downward, not provide security for cost if you think it's warranted, but you may have to be more conservative with your numbers, because you cannot put a party in a worse financial situation just generally by granting that order. That would not be fair. That would breach the proportionality requirement.
And at the same time, it might jeopardize that party's access to justice, which in the end is the problem. And there's some hesitation about what is the consequence of not complying an order for security for cost, precisely because of this right to access justice.
There was a slightly related question about what elements the tribunal or the emergency arbitrator should take into account when setting the amount of the guarantee if they're ordering measures. Do you have any useful tips there?
I mean, the classic criterion is, what would be the costs of actually providing the measure, and expenses. So it's not usually, I mean, unless exceptional cases, it's not usually extortionate amounts, but it has to be realistic enough to be meaningful. And so that if there is a difficulty, then that amount can be taken as compensation. I mean, classically, it would be in the order of, I don't know, 100, 200,000 pounds. That sort of figure is what you tend to see in the average middle range case. And obviously you have cases that, all through the spectrum.
Maybe I must confess that I believe that we covered the main questions, but it's a lot of comments and questions coming out. So maybe Thomas will send me if I missed any. But otherwise, maybe to conclude.
There is, sorry, Živa, but very quickly, there's a question here that we sort of touched upon, but not really covered. It might be worth saying in very short time. Someone asking, is there not, why don't we go to courts? Because courts have coercive powers, and that would be a strong argument to sort of bypass the tribunal anyway. And that's obviously a fair question.
Well, some courts have been shut down during this period, and some courts are now starting to operate. I know my domestic country's courts are struggling very much. There is a huge backlog, and the beauty of arbitration is that it has really showed how resilient it is to crisis like this. And at the ICC, I remember at the beginning of the lockdown, where everybody was in shock, we had an emergency arbitrator that went very smoothly, and the parties, both sides, even the side that lost, wrote to us to congratulate everybody on the smooth handling of it. So I think one needs to balance the speed the effectiveness of obtaining relief with what they can actually obtain. And there are cases where the fact that the arbitrator doesn't have coercive powers doesn't really matter so much. And there are cases in which it's a deal breaker. I don't know if Eduardo, if you want to add.
There are two elements that militate in favor of arbitral interim orders. First, the possibility of enforcing those as awards in all countries having ratified the New York Convention, which is not the case of judgments, as we know. And secondly, within the setting of arbitration with states or state entities, it may be the case that the judges of the state will not grant measures because of some provisions in administrative law against those, and hence the only way to get orders against the state or the state entity would be through arbitration, either emergency arbitration or let's say the definitive arbitration.
Maybe a few other things to consider in choosing between. It's not exactly for arbitrators, but it's an important topic. I mean, one advantage of going to the tribunal is also that the tribunal has already been briefed by the district. It's not going to a judge that has never heard of you before. So that adds to efficiency, probably. And the thing we touched upon before, that the tribunal is the one instructed with the case on the substance. So it will also have other means of incentivizing compliance. One is, of course, it can order compliance. It can order peremptory orders, for example, in England, right, or where they are available. It can also order adverse inferences in the main arbitration. It can also consider compliance with the interim measures at the end of the case when allocating costs between the parties. This is what comes to mind immediately. I'm sure that I'm missing something as well. But there are quite a few soft means of influence that the tribunal has that the court doesn't have.
Absolutely.
Thomas is here to tell us that our time has expired.
Yeah, close enough. I mean, unless you have any round robin of final things that you wanted to end on. Otherwise, we can wrap it up.
Eduardo and Sophie?
No, only to thank you.
We've gone through the list. Fantastic. Okay, so Živa, is there anything that you wanted to mention before we close out?
No, just to thank everybody, to our speakers, for this really insightful discussion, and to the many, I don't know how many we had at the end of the 750 registered applicants. And please check the chat. I think that there are very useful resources there, including the ICC Commission report on emergency arbitrator, which is really useful source also for the parties and tribunals, also for interim measures by arbitrators, not only emergency arbitrators.
Right. Well, I also want to thank all three of you for making the time. I know that it's busy, incredibly busy for all of you, but we managed to make it work. So it's really great. And also for the audience who are still with us, again, thank you for making the time. As a reminder, we are hosting live broadcasts on this topic, in addition to other trade topics like the Incoterms rules, cryptocurrency, and leadership coaching, and many others. So if you sign up on our website for free and subscribe to our YouTube channel, there you'll see a bunch of other arbitration-related videos, which I think would be useful for you. But otherwise, in the meantime, ladies and gentlemen, this wraps up another episode of the COVID-19 briefing. See you next time. Thank you again.